Welcome, everybody. Welcome to another impromptu, not very well scheduled Law of Self-Defense show. I'm so glad all of you could join me on short notice, whichever ones of you could join me on short notice. If you may not know, I am, of course, attorney Andrew Branker for Law of Self-Defense. Thank you. Thank you. But for the chat, my ego would be even larger. Imagine the horror, So let's see, this appears to be working. YouTube, Rumble, let's see. Check out Twitter. Make sure that's going. Let's see. It is. And finally, the Law of Self-Defense member dashboard is also working. Awesome. So welcome, folks. We're going to talk today about your legal privileges when your home is violently invaded. As you might expect, defending against a home invasion, home intrusion is about as clean a self-defense scenario as you could hope for, but people still do mess it up. The good news is that most states have very, very generous use of force privileges for defending your home against a violent, unlawful intruder, and we're going to explore one example of those. We're going to use the Texas version of those defense of highly defensible property laws. But the structure is pretty common across many states, more than half the states, I believe. So it's a good illustrative example. And we have video. We have video of the home intrusion, the violent home intrusion occurring. And we'll explore what our legal options are. We'll explore why Castle Doctrine, which I think many people would assume would be the most important legal doctrine in the context of a home intrusion, isn't by far the most important. The most important is what we'll talk about as a legal presumption of a reasonable fear of imminent deadly force harm at the hands of that violent, unlawful intruder to your home. That's a truly potent statute. Castle Doctrine's nice. I like it. We ought to have it everywhere, and every state does have some version of Castle Doctrine, but most people misunderstand what Castle Doctrine is. It's really quite a limited legal doctrine, and we'll explore just how limited it is. It also comes in many different flavors that can limit it even further. We'll explore all of that and much more. So before I get to the video, I should, of course, mention that the sponsor of today's Law of Self-Defense show is none other than, where's the drum roll? I need a drum roll sound effect. Oh, good heavens, where is it? It looks like I failed to open it up. Hold on. I know you all come here for the production value. I have every confidence in the world that you're looking for boomer level production values in order to be a happy participant in these Law of Self-Defense shows. And we bring it to you good and hard every day, folks. So the sponsor of today's content is no other than Law of Self-Defense itself. We're holding our only scheduled Law of Self-Defense advanced class for all of 2023 on Saturday, April 15th. This is a full day live class taught personally by me, streamed to you at your computer. And in one day, a very full day, but in one day, you can learn really everything you need to know to be hard to convict, to be an unattractive target for prosecution if you're ever compelled to use force in defense of yourself, your family, your property. Now, I see someone comment from Canada in the chat. I wish I could do a course like this under Canadian law, but I just don't know Canadian law. So this is a U.S. specific course, but it does apply to all 50 states, so it doesn't really matter what state you come from. And by the way, folks, if you can't make it on Saturday, April 15th for the live broadcast, we do make every student have access to the replay of this class. And again, we're only teaching it. It's only scheduled once this year. This is the only date. So if you can't make Saturday, April 15th, I would still encourage you to register, and we'll send you an email with the replay of the course probably the next day. We have to do a little production work on those very lengthy recordings. And if you sign up for this class this month, the month of March, you get 10% off your registration. If you wait till April, it's just the normal price, folks. It's full price for the course. You can learn more about this at lawofselfdefense.com/advanced. That's the registration page, but we also have a lot of additional information on the course, including a little video by me with more details and how we answer more than 100 very specific use of force law questions over the course of that class. Questions you probably don't know the right answers to. You may think you have answers, but in my experience, mostly students have bad information on use of force law. So learn more, register at lawofselfdefense.com/advanced. I should also mention, of course, our best-selling book, Law of Self-Defense Principles. Check it out on Amazon. Over 1,200 ratings, 4.8 stars. We can round that up to 5 stars. But don't buy the book on Amazon because they'll charge you for the book and shipping and handling. We'll give you the book for free. We only ask that you cover the cost of getting the book to you. It's a real book, not just some PDF download, folks. You can get this book, the soft cover, for free. Just cover the shipping and handling at lawofselfdefense.com/free book. Simple enough. Or if you'd like the very handsome hardcover book, it's really, really nice. Looks on the bookshelf, makes a great gift. You can get the hardcover version at lawofselfdefense.com. You know where. lawofselfdefense.com/get-hard. All right, that is all the ads. So what we have here is a little video of a adult male and woman. The male violently breaches the home, appears to kick in the front door, although he's being shouted at by the residents to stay away, stay out. He kicks in the front door. A woman follows him into the home as he crosses the threshold. So we have violent, unlawful intruders into the home. Now, apparently, they're under a misimpression. They think they're at the home of somebody who just ran their daughter over with a car. They're very upset. Apparently, the person who ran over their daughter provided this address. It's not the bad guy's address by all accounts. We don't really know anything about the accident per se, but the man and woman who violently breached the home, that's what they're quite upset about. The homeowners, of course, have no knowledge of any of this. And I should say up front, so this is from, I found this on Twitter. In fact, I should probably pull up the Twitter account where I found it. Let me see if I saved that to give that person a little bump, because I wouldn't have this content but for them. And I do. So let me pull that up. This is the tweet where I found this content. So it's the Twitter name is Texas TX Deplorable. The handle is at Texas_Made956. Made is MADE for those listening to the podcast version of this. And he asks, what are y'all doing in this situation? And what he's embedded here is the TikTok video of the violent home intrusion that we're going to watch. Now, I should say up front, I actually have no idea where this intrusion occurred. I don't know that it was in Texas. I just chose Texas because this Twitter account has Texas in the name. So for didactic purposes, for purposes of education, we're going to pretend this is Texas. The legal analysis would be the same in any state that has a similar defense of highly defensible property statute, a legal presumption of reasonable fear statute that Texas had, but that's many, many states. If you don't know if your state has such a statute, you might want to know. We do have state-specific courses of instruction for all 50 states in the U.S. You can find your state, get the DVD, or download, or rather access the online course, and learn all the use of force law for your state, your specific state, at lawofselfdefense.com/state. But for our purposes, we're going to pretend or assume that this event occurred in Texas. Because we have to pick some state, I don't have time to go through 50 states worth of defense of highly defensible property law in one show. So I'm going to play you, I prepared a long and short video version of this event. We'll play the long one first. It's not very long. It's under 3 minutes. Most of it's not particularly relevant for our purposes, but I think it's useful to go through the whole thing, mostly because it's amusing. And then we'll do our legal analysis, and then I'll play the short version, which is just a few seconds long. Before I do that, just a reminder to everybody, if you'd like to ask questions in the chat and have them answered by me, feel free to do that. If you're watching on YouTube, that needs to be a super chat of at least $5. $5 minimum, folks. If you're watching on Rumble, it needs to be a Rumble rant, same dollar amount, $5 minimum. If you're watching on Twitter, where we're also live streaming, I don't bother answering questions there. Sorry, folks. If you're a Law of Self-Defense member, ask as many questions as you want, and there is no charge. No charge for Law of Self-Defense members watching on the member dashboard. Just put your questions in the chat, preface it with the word question in all caps, and I'll answer as many questions as you like for no additional charge because you're Law of Self-Defense members. And by the way, for those of you paying $5 super chats and Rumble rants to get your questions answered, for less than $10 a month, you could get all your questions answered. Less than 30 cents a day. Get all your questions answered and not have to pay $5 a pop. Ask 100 questions in the course of a month. For less than $10, I'll answer them all. Something to consider. You know, you do you, but the cost-effective way is definitely to be a Law of Self-Defense member. You can become a member right now instantly at lawofselfdefense.com/join. And then you could join us in the member chat and ask all your questions there, or do the $5 a pop thing. It's entirely up to you. So before I jump into the specifics of the Texas Defense of Highly Defensible Property statute, which isn't really a standalone statute, it's just part of Texas's self-defense statute, really. That's just the way they structure it. Some kind of general framework to understand what we're talking about here. So we have, of course, laws of self-defense, defense of yourself, defense of other persons, and those are based around the 5 elements of self-defense, which we talk about all the time here: innocence, imminence, proportionality, avoidance, and reasonableness. I'm not going to cover these today because this is not really a self-defense case, but it always involves some explicit, apparent, reasonably perceived imminent threat to another person, either yourself or somebody else. A threat to property, in the absence of a threat to persons, is not a self-defense argument. It's a defense of property argument. So these elements do not apply to defense of property. You're making a different legal argument. This is for defense of persons. By the way, we make this little 5 elements cheat sheet available for free to anybody who wants it. If you don't understand this, folks, you can't possibly understand defense of persons law. These 5 elements, or the maximum of 5, apply in all 50 states. You can get this cheat sheet for free. For free, we don't charge a penny. It's just a PDF download at lawofselfdefense.com/elements. Clear my throat there. lawofselfdefense.com/elements for that. So we're not talking about defense of persons here. If we are talking about defense of persons, if there's an intruder in your home and he threatens you or another person, then it's not really defense of property anymore. Then it's defense of persons. And you always want to make the defense of persons argument if you can on the merits, because that's the strongest use of force argument. But what if you have an intruder in your home and they're not yet explicitly threatening you with imminent death, for example? Let's presume there's a threat to property, but not to persons. So it's not a use of force defense of persons case. It's a use of force defense of property case. Well, we divide property into 2 buckets. There's highly defensible property. There's least defensible property. Highly defensible property typically always includes your home, for sure. It may include a place of business. It may include an occupied vehicle. The scope of what qualifies as highly defensible property does vary quite a bit state by state. Generally speaking, defense of property law varies a lot more state by state than defense of persons law. And this is reflected in the scope of what qualifies as highly defensible property. So that's one bucket of defense of property law, is the highly defensible property bucket. And then we have the least defensible property bucket. And that's for property that's just personal items, a coat, a laptop, whatever. So for our purposes, now Texas is an exception, and we are imagining we're in Texas. In 49 states, if we're talking about least defensible property, the most in the absence of a threat to persons. Remember, if there's a threat to persons, it becomes a self-defense case. But if we're talking about defense of least defensible property, someone stealing your coat off the hanger in a restaurant, you see him doing it. You can only use non-deadly force in defense of least defensible property. Texas is the one exception. In Texas, there is a legal provision, Texas Penal Code 9.42, that allows, under very specific circumstances, for the use of deadly force in defense of even least defensible property. No other state does that. I encourage you to read 9.42 just so you're informed. You can find that at lawofselfdefense.com/942. I would also discourage you from doing it, because if you screw it up, defending least defensible property with deadly force, you've killed someone, and there's some defect in your claim of deadly force in defense of least defensible property under 9.42, the outcome is the rest of your life in a cage. There's not a lot of least defensible property that's worth risking the rest of your life in a cage. But you make that call for you. I don't tell people what to do. That's the relevant Texas statute for deadly force in defense of least defensible property, lawofselfdefense.com/942. But that's not what we're talking about here. We're not talking about least defensible property, right? No one is, this is not a scenario where someone's stealing your kid's bicycle from the sidewalk in front of your home, right? We're talking about highly defensible property. And the Texas statute will provide the Texas definition of highly defensible property. But again, that always includes your home. So we're talking about a home situation here. The ultimate, the quintessential highly defensible property. Every state includes your home as highly defensible property. Some states expand the definition beyond that, but all include your home. Of course, there is a legal doctrine called Castle Doctrine. And unfortunately, it's poorly misunderstood. It's generally believed to do much more than it does. Castle Doctrine does not provide you with a privilege to use more force than you otherwise would have been allowed to use. It doesn't provide you with a privilege to use force sooner than you otherwise would be privileged to do. Castle Doctrine does one very specific thing, and frankly, it's mostly irrelevant in most states at this point. Every state has some version of Castle Doctrine, but it's really of quite limited scope. Properly understood, the only thing that Castle Doctrine does is relieve you of an otherwise existing legal duty to retreat. So if you are out on the street in front of your home, a public street, let's assume, and you would have had a legal duty to retreat before you could have defended yourself, Castle Doctrine relieves you of that legal duty to retreat if you're in your home. That's all it does. It relieves you of an otherwise existing duty to retreat, which means if there wasn't an otherwise existing legal duty to retreat, it really doesn't do anything for you. So most states are, 40 states are, about 40, are stand your ground states. You already don't have a legal duty to retreat anywhere you have a right to be. So you wouldn't have a legal duty to retreat if you were defending yourself out on the street in front of your home. Well, if that's the case, you don't need Castle Doctrine to relieve you of a duty you already don't have. Does that make sense? Now, stand your ground and Castle Doctrine are a little different. Many states, about half the states, have adopted stand your ground by statute. Anytime a statute is made, there's debate, there's compromise. It's making sausages, right, legislatively. And there are many states that have their statute, their stand your ground law has conditions to qualify for stand your ground, like you can't have been engaged in unlawful activity at the time, for example. So you might be out on the street defending yourself, but maybe, let's pretend, hopefully not, but let's pretend you're out on the street selling drugs, an unlawful activity. If that's the case, you would lose your stand your ground privilege. You wouldn't qualify for stand your ground. You would have effectively reacquired a legal duty to retreat, even though generally speaking, your state is a stand your ground state because you failed to meet the conditions for stand your ground. That same person, if they were in their home, would still qualify for Castle Doctrine because Castle Doctrine doesn't have the condition of not being engaged in unlawful activity. So in that sense, Castle Doctrine could apply in that kind of circumstances. You may fail to qualify for stand your ground, depending on the version of your state stand your ground law, but still qualify for Castle Doctrine. But again, all Castle Doctrine does, all it does, is relieve you of an otherwise existing legal duty to retreat. So you're in a confrontation with someone in your home, you're defending yourself, and Castle Doctrine says, even if you would have had a duty to retreat outside the home, you don't have a legal duty to retreat defending yourself inside your home, because your home is your castle. And one of the reasons, and Castle Doctrine is very old law. For our purposes, it dates back to Old English common law. It's long been the rule. I guess that's why they call it castle, right? A man's home is his castle. But the legal principle, the public policy principle, relieving you of that otherwise existing legal duty to retreat, is that the whole idea of a duty to retreat is, theoretically, there's a safer place for you to go. And if you can achieve safety by simply leaving the confrontation, the law wants you to do that before you kill someone. But if you're in your home already, that is the place of maximum safety. There is no safer place to go if you're in your home. And that's why Castle Doctrine relieves you of that otherwise existing legal duty to retreat. Now, having said that, Castle Doctrine does come in different flavors in different states. Castle Doctrine can vary in terms of what qualifies as a castle for your purposes. So some states say, if you're defending yourself and you're in anybody's castle, so you're in your home, or you're visiting your parents' home, or you're visiting a neighbor's home, you're in a castle, you're relieved of that legal duty to retreat. But other states say, well, no, we don't want to do it that way. We're going to give you Castle Doctrine privileges. We're going to relieve you of your otherwise existing legal duty to retreat when you are in your castle, but not when you're in someone else's castle. When you're visiting your neighbor's house, they have Castle Doctrine privileges in their house. They are relieved of an otherwise existing duty to retreat in their castle, but it's not your castle. So you still have a legal duty to retreat if you otherwise would have, right? Another way that Castle Doctrine varies from jurisdiction to jurisdiction is the scope of the castle. So your castle always includes within the four walls of your home, which is what we'll see here in this video. It occurs within the four walls of the home. So that's not a problem here. But sometimes Castle Doctrine also, not always, varies by state. Most often, Castle Doctrine also includes what's called the curtilage around the home. And that's outside the four walls of your house. That's the area immediately, curtilage is the area immediately around your home. That's part of the normal day-to-day function of your home. For most typical homes, it would include a front porch, a back porch, a front yard, a backyard. If you live on 40 acres, it probably doesn't include that 40th acre, because you probably don't go there as part of your day-to-day routine. Maybe you're a farmer and every day you're on every acre. Then I would argue that's still curtilage. But if you just have a lot of land and you don't generally go to every part of it, those parts you don't normally go to, I would argue, would not qualify as curtilage or not part of the day-to-day use of the home. It can also, that can vary too, what qualifies as part of the day-to-day use of the home. Now, imagine there's a farmer, he's got a barn near his house, right? 50 yards away, 100 yards away from his house. While that property is being worked as a farm, that farmer is in that barn every day. Reasonably enough, I would argue that barn is part of the normal day-to-day function of the household, qualifies as curtilage. But what if that farmer sells his farm to a nice couple of uncertain gender from Vermont, and they decide to turn it into a bed and breakfast? Well, they're not using the barn anymore. It's just sitting there, completely unused. They never go out there. It stinks. So in their use of the property, I would argue the barn no longer qualifies as curtilage because it's no longer part of the normal day-to-day use of the home. The characteristic of the property has changed in the context of the barn. Detached garages can be much the same thing. structures that might be used seasonally. So maybe you have a shed where you keep a snowblower, and in the winter you're out there every day, pretty much every week, routinely to get the snowblower to clear your driveway or whatever, but in the summer you're not. So whether that shed is part of the normal day-to-day function of the home can even be seasonal. Castle Doctrine can also vary in terms of whom you can claim Castle Doctrine privileges against. So you're in your castle, it's your castle, and suddenly you're dealing, excuse me, folks, I'm gonna, one second, let me see if I can get something to, I shouted for Emily, and hopefully she'll, hopefully a bottle of water is coming in. Okay. Going crazy. Not quite like Nick's show, is it? A lot of water. But I await the law of self-defense chalice, the mug of law of self-defense. By the way, if you like these mugs, we do make them available. You can get them at lawofselfdefense.com/mug. Law of self-defense on one side, hard to kill, hard to convict on the other side. They're quite nice, and they're made in America, folks, which unfortunately makes them a little costly. Sorry about that. We looked at a bunch of Chinese samples, and I just couldn't bring myself to do it. So our mugs are made in America, and you can get them at lawofselfdefense.com/mug. Okay, where was I? Right, Castle Doctrine. So Castle Doctrine also varies in flavor depending on against whom you can claim Castle Doctrine privileges. In this video, we're dealing with strangers forcibly, unlawfully intruding into a home. You always have Castle Doctrine privileges against an intruder in your home. But you might not against someone who's a co-dweller in the home, because it's also their castle. So you may live in an apartment with apartment mates, or you may be married, have a spouse, and all those people in the home, it's their castle as well. And a lot of states say you have Castle Doctrine privileges against an intruder, but not against a co-dweller. So if you're attacked by your spouse, you may not have Castle Doctrine privileges, or attacked by an apartment mate. This could also apply in many states to an invited guest. So that could be someone you invite, say, to a party in your home, or it could be a repairman you invite into the home. But if they're invited into the home, it's common for you not to have Castle Doctrine privileges against an invitee. The easy part of that, of course, is you can instantly turn an invitee into a trespasser by telling them to get out and giving them a reasonable opportunity to get out. And if they don't get out, well, then they're a trespasser. Then they're an intruder, and you have Castle Doctrine privileges again. Now, just like with stand your ground, of course, if there is no opportunity to retreat, there's never a duty to retreat anyway. I mean, there cannot be a legal duty to do something that's impossible. So even if you're in your home, say it's a co-dweller or an invited guest, and for that reason your state says you don't have Castle Doctrine privileges, if your back's already against the wall, or there's no completely safe opportunity to retreat, well, then you would never have a duty to retreat regardless. So that's Castle Doctrine. And I talked about it at length. I'm not sure why, because it doesn't apply to this situation at all. In hypothetically in Texas, which is where we're assuming to be. But the important part I want you to take home is that that's all Castle Doctrine does. If the law would have said you have a legal duty to retreat, you're relieved of that legal duty if you're in your castle. That's Castle Doctrine. All it doesn't let you use more force than would otherwise be permissible, doesn't let you use force sooner than would otherwise be permissible. All it does is relieve you of an otherwise existing legal duty to retreat. But there are other laws, other legal doctrines that give you a lot of additional privileges for the use of deadly defensive force in defense of highly defensible property. We don't have a cool name for these, like Castle Doctrine. I refer to them accurately but ponderously as a legal presumption of reasonable fear in defense of highly defensible property. But that's really what they do. They say basically if you're defending your occupied, highly defensible property, and that always includes your home, might include a business, might include an occupied vehicle, but always includes your home, and you're dealing with a forcible and unlawful intruder, usually both are required, forcible and unlawful, Those are present here, so we don't have to worry about it in the video we'll be looking at. You're in your home, highly defensible property. You're dealing with a forcible, unlawful intruder. The law presumes that you had a reasonable fear of imminent, unlawful, deadly force harm at the hands of that intruder. Folks, that effectively makes the defense of property scenario a defense of person scenario because it's giving you every element you need but one to justify your use of deadly defensive force. Remember what the elements are: innocence, imminence, proportionality, avoidance, and reasonableness. I'm going to show you the Texas statute on this, so we have specific statutory language to work with. But what you'll see is that the legal presumption establishes a presumption that you have the elements of imminence, proportionality, and reasonableness. They're presumed to exist. Castle Doctrine covers you on avoidance. So that's 4 of the 5 elements that are presumed to exist. The element of innocence isn't directly touched upon by these statutes, but let's face it, innocence has to do with whether or not you're the aggressor or the other guy is the aggressor. And if someone just kicked your door open in your home, innocence is pretty much baked into the cake, right? That's different than if you go outside to chase them, which is one way people screw up, which should be highly defensible uses of force. But these are the 5 elements, and the legal presumption of reasonableness in combination with the Castle Doctrine gives you 4 of the 5, and the 5th is basically baked in the cake. That's why defensive home scenarios are so hard to screw up. That's why if you're a member of the NRA, you get one of the NRA magazines. I'm a member of the NRA, have been all my life, lifetime member since I was very young. You get one of the NRA magazines, American Rifleman, American Hunter, First Freedom. They have so many now, I can't remember them all, but all of them share a common page called Armed Citizen with little vignettes of people using force in defense of themselves or their home or their property. And it always works out great for them. They're never charged. It works out bad for the bad guy. The bad guy gets chased off or he gets mortally wounded or whatever. But it works out great for the defender. They're never arrested. They're never charged. They're never prosecuted. And if you'll notice, when you look at them more closely, most of those scenarios, at least in the last few years, it used to be more varied, but most of the scenarios they include in the armed citizen column these days are defense of home scenarios because they are so hard for a prosecutor to overcome. One reason they're hard for the prosecutor to overcome is these defense of highly defensible property statutes, like we'll look at in just a moment. Another reason, though, folks, is even if you're in a state that doesn't have one of those special legal presumptions of reasonable fear when dealing with an intruder, even if you don't have that, it's so hard for a prosecutor to overcome a jury's resistance in these home defense cases because jurors don't know anything about self-defense law, although they're instructed by the judge, but they don't know anything going into court. They don't know anything about guns, defensive tactics, terminal ballistics, how pepper spray works. They just don't know. They don't know any of that. But what they do know is they all live in a home. Every one of those people lives in a home, and they know what it would feel like to have someone kick their door in and come into the house. It's very difficult for prosecutors to overcome that. But it's always helpful to not just rely on that, but also have the benefit of these defense of highly defensible property, legal presumption of reasonable fear statutes. So I'm going to play the video now, the long form of the video. And then we'll take a closer look at the, let's see, that doesn't really work. That's about as big as I can make it. It is a TikTok video, folks, so we have these odd proportions. There was cursing in this. For those of you who are sensitive to that, I was raised in New York, so I'm kind of deaf to foul language. I've done my best to bleep it out. It was not bleeped in the original. I actually had to go put the bleeps in, which I did because I love all of you that much. But it's always possible I missed one or another curse word. If I did that, I apologize. That's not my area of expertise, but I did the best I could. All right, so before we actually jump into the video, let me take a quick look and see if there's any super chats or Rumble rants that I already need to take a look at. Because sometimes if I wait too long, those go away. Let's see. Let's see. No super chats yet. Let me take a look at the Law Self-Defense member chat. Let's see. All the usual suspects. Law Self-Defense members, Steve B. Pyro asks, does New York State have a Castle Doctrine? Every state has some version of Castle Doctrine, including New York. Doug from Minnesota, Jim from Tennessee, Charles from Oklahoma, Stogies from Tuttle, Oklahoma. I like parts of Oklahoma. Parts of it are real flat, but other parts of it are pretty nice. Let's see. Stogies and Boomsticks, Law Self-Defense member asks, why do so many folks conflate murder with self-defense? Is it because they are being disingenuous, or do you think that they truly do not believe there's a difference? How do we disabuse them of such nonsense as members of the Second Amendment and self-defense advocate community? Well, I mean, I think most people are they're just misinformed. They're ignorant. I don't mean that in a derogatory sense. I mean that in a technical sense. They're ignorant of the law and what these words mean legally. There's lots of words we use colloquially, in normal conversation. But when we're speaking legally, these are legal terms of art, right? So we have the word homicide. Homicide just means one person killed another person. It's got nothing to do with whether or not the killing was lawful. Any killing by one person of another person is a homicide. If it's done in lawful self-defense, it's not a crime. It's lawful self-defense. If it's done unlawfully, it's murder or manslaughter, some form of unlawful killing. But homicide, it branches off, the lawful ones and the unlawful ones. It's why I always laugh when I hear the gun control people say, well, stand your ground or open carry or whatever was passed and homicides went up. I don't care if homicides went up. I care who's doing the dying. I mean, some homicides are a social good, right? A woman who's compelled to shoot the guy trying to rape her and he dies, that's lawful self-defense. That's a social good. So homicides to me is a completely neutral term. And I think it's a mistake sometimes for police departments of, well, I guess homicide investigations are trying to determine what kind of homicide it is. Things like vehicular homicide, I don't know. But these are specific terms of art. So you can't murder someone in self-defense. Either it was a murder or it was self-defense. That's just the way it works. I think a lot of people are just ignorant of the proper use of those terms. Of course, some people are basically political operatives. The gun control groups, they love to conflate these terms to create confusion. The important thing is that you know what they mean. And if you want to educate others, that's up to you. Let's see. Doug from Minnesota says, in Minnesota, we do not recognize any curtilage. I have had students ask me if their traditional attached garage would be considered part of the castle. Do you know how garages are considered in a no curtilage state? So, yeah, I'm not sure about that in Minnesota. I'll have to check. Definitely in Massachusetts, there's no curtilage for use of force law purposes. So I've seen appellate cases in Massachusetts where the defender had 1 foot outside his front door. The rest of his body was inside his house. No Castle Doctrine for him. Minnesota is a liberal state too, so it wouldn't surprise me if that was the same rule there. An attached garage is typically treated as part of your castle. It's connected to your home. It's part of your castle. Where people get in trouble is a detached garage. That's treated differently because it's no longer attached to your home. And by the way, curtilage in general is not something I would encourage you to rely on, because there's usually no black and white definition of the scope of the curtilage of your property. I define curtilage as the area around your home that's part of the normal day-to-day activity of your home. Well, who decides that? That's decided on a case-by-case basis by the judge, if he wants to give a curtilage instruction to the jury, by the jury, if they even get that instruction. So it's just a completely subjective judgment call being made by other people, not by you. Some states will explicitly include particular things. I think North Carolina, for example, the curtilage statute may specifically include a front porch, a back porch. And then, if it's defined in black and white like that, but like how far down your driveway are you still in the curtilage? You don't know until someone else makes the call. And when they make the call, it goes against you, you're convicted. So I'd be very cautious. I mean, the curtilage is an argument your lawyer will make, and hopefully he'll make it well and it'll be in your favor. But I wouldn't rely on curtilage to keep me out of prison. I would much prefer, if it had to come to that I was in a circumstance where I was actually inside my home. I mean, this came up in the St. Louis case, right? With the husband and wife, the Black Lives Matters or whatever it was, protesters were outside their home. They felt threatened. They stepped out on their front yard with the AR and the gun that looked like a PPK. I don't remember what it was, in the hands of the wife. If it were me, I would have stayed inside the house and just, went about my business. I'm normally armed anyway, even inside my house. And just if someone breached a home, completely different ballgame. But out on the front yard, I mean, I'm not saying they didn't have the right to do it. I'm not saying they should have been charged. I think it was just that the charges that were brought against them, I think they pled to something minor, and then even that was pardoned. I forget the details. So I'm not saying people shouldn't have the privilege to do it. I'm just saying I'm not sure it's prudent from either a legal or a tactical perspective. I would stay inside the home, if at all possible. Now, if people are outside but hurling stuff inside, well, then they're entering your home. If they're throwing rocks through your window, they're entering the home. They're throwing Molotov cocktails at your home. They're effectively entering your home. Let's see. South Dakota on the member dashboard, North Carolina. Law self-defense member says you will wear yourself out trying to educate libs. There's a point of pointlessness. Yeah, I don't actually try to educate people who can't be educated. But sometimes those people on social media, particularly on Twitter, they're useful as foils for didactic purposes. I think of them as little puppets, because there's lots of people watching the exchange besides them. So I don't care if I educate them, but hopefully I'm opening up the eyes of other people. Let's see. All right, that's all the members. Let me refresh the super chat. I see a lot of questions in the chat, folks, but I don't answer questions unless they're a $5 super chat. So I kind of said that going in, I believe. And Rumble is all clear too. All right, let me pull up the video then. We'll get right to it. This will certainly get me demonetized immediately, even though there's no real violence in it, but there's a lot of shouting. And I'll do the long version of the video here first. I did a little audio work because the home dwellers, the residents, were very loud and the intruders were quite soft. So I kind of normalized the sound a bit. I'm not sure how much it helped, but in any case, here we go. In fact, let me do this. This will make it a little bit bigger. There we go. Here we go.
This is the wrong house. Go away. This is not your house. Get the away. This is not your house. Go away. What the
Wait, I want my money.
This is not the right house. This is not the right house.
Where is he?
Who are you looking for?
Where is he?
Who are you looking for?
Get out here now.
Who are you looking for?
Where is he?
Let's go. The cops will handle it. Let's go.
Where is he?
Who?
On video.
Who?
Where is he?
Brother.
Your brother.
I don't have a brother. I don't have a
You
brother.
might be at the wrong house.
Who are you looking for?
What's his name, Haley?
What's his name?
I am so sorry.
Hold on.
He hit my door with a car after
He hit my door.
These people are lucky they're still
We have been
alive.
here the entire time. We have not left the house.
I'll pay for this. I'm sorry.
Okay.
I'm sorry.
Who are you looking for?
Come here. Come outside. I'm sorry.
I'm not coming outside.
No, I'm sorry.
No.
I thought.
Yeah,
Stay
don't go
away,
outside.
Who are you looking for? This is the wrong house. I'm sure.
I'll pay for it.
Okay. What's your name?
What's his
Oh,
name?
yeah.
What's his name? Waylon.
We do not know anybody with that name.
Oh my God, you're at the wrong house. They said that he gave this address.
This is the wrong address.
I am so sorry.
We do not know anyone with that
I'm
address.
so scared. He ran my daughter over with a car.
Take money.
I don't want money. We just want you to leave.
I'm
Take it. I'm sorry. Take it. I'm
He
sorry.
gave your address.
He gave me your address.
I don't even live here.
I am so sorry.
Why would you not have
Oh, people are crazy.
We have the police.
I don't think so.
We have the police.
Can you just-
Here's 200. Here's 200. I'm sorry.
Can you just give us your name or your phone number?
Yeah, Robert.
Yeah.
I wouldn't care about any of this. Get
I
He's
out.
don't
a
know what's going on.
contractor.
I don't want your money.
I am so
He gave
sorry.
this
You
address.
do not do this.
I mean,
This is illegal.
they'd almost
You
certainly
can
be
take
bleeding
legal
by now.
action
I
against
understand it.
Please-
He came in my house. He put
Please
my
just
phone
leave.
over.
Please just
He
leave.
ran
That is
my
so
door.
Please just
illegal
leave.
to the police.
Please just leave. Please just leave. Please just leave. Thank you.
All right, so that's the long form of the video. Now, as I said earlier, we're pretending this took place in Texas. I don't know where it occurred, but the person who posted it on Twitter, this is a TikTok video originally. They posted it on Twitter, and they have Texas in their Twitter name. So just for educational purposes, let's pretend this is Texas. So what do we have here? We have a forcible, unlawful intrusion into a home, right? By strangers. Hold on a second. Sorry, folks, but you have to interrupt the show when your wife wants your wallet. There you go. All right. And then people wonder why I never have cash. All right, let's get back to the show now that I've been the victim of a strong arm robbery. So we have a forcible, unlawful entry into the home by, obviously, strangers, intruders. Clearly, these homeowners would have Castle Doctrine privileges against an intruder into their home. But Castle Doctrine is not really what's important here because, again, all Castle Doctrine does is relieve you of an otherwise existing duty to retreat. It doesn't allow you to use more force than would otherwise be the case or use force sooner than would otherwise be the case. Doesn't do any of that. What does do that is the Texas law on defense of highly defensible property, creating a legal presumption that the defender had a reasonable perception of an imminent unlawful threat of deadly force harm, meaning the defendant, that's just presumed to be the case. Those elements are met. Those would be the elements of imminence, proportionality, and reasonableness, as we'll see in a moment. And of course, avoidance, whether there's a legal duty to retreat, is addressed by the Castle Doctrine. And if you're sitting in your home and someone breaks in, there's no ambiguity about who the aggressor is. So the element of innocence. Basically, these laws give you every legal element required to be justified in using deadly defensive force against that person. So having said that, let's take a look at the actual statute itself. Now, many states kind of break up these kind of legal doctrines. Defense of self might be one statute. Defense of others might be another separate statute. Defense of highly defensible property might be a third statute. Defense of least defensible property, yet another statute. But other states tend to combine these different legal doctrines into one lengthier statute, and Texas does that. So they take their defense of persons statute and they fold into that defense of highly defensible property. It's not how I would structure statutory language, but that's how Texas does it. So let's pull it up right now. So this is it. It's Texas Penal Code 9.32. Now, Texas, like many states, this is quite common. The element of proportionality, of course, differentiates in terms of intensity of force between non-deadly force and deadly force. So many states will have a non-deadly force statute. And so it just defines these are the conditions that have to be met for non-deadly force to be lawful. Then they'll have a separate deadly force statute that adds additional conditions. Texas does that. So 9.31, which I'm not showing here, would be non-deadly force in self-defense. 9.32 is deadly force in defense of persons. And even though the statute is titled defense of persons, it also addresses defense of highly defensible property, as we'll see. So under Texas law, a person is justified in using deadly force against another if they first meet all the conditions for using non-deadly force against another, which is what Section 9.31 addresses. So first you have to meet all the conditions. Before you can use deadly force in self-defense, you have to meet all the conditions for non-deadly force. And then there are additional conditions. To use deadly defensive force, you have to meet all the conditions for non-deadly force. And you also have to believe deadly force is immediately necessary to protect you against an unlawful deadly force. So you can't use deadly defensive force unless you're being threatened with deadly defensive force. That's proportionality, deadly force to deadly force. Or if you're being subject to the commission of this enumerated list of forcible felonies: aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery. Of course, almost all of these would involve some threat of death or serious bodily injury, which is the definition of deadly force. But it's always nice when they enumerate those forcible felonies, provides clarity. So the conditions for, I'm not going to pull 9.31 up, but you need to, in Texas, for non-deadly defensive force, you're only using non-deadly force, you need to have been the innocent victim of unlawful, imminent, non-deadly force. Texas, as we'll see, is a stand your ground state, so avoidance is off the table. And your perception of that threat has to be a reasonable perception. So you genuinely believed it, and your belief is objectively reasonable. A theoretical, reasonable and prudent person would have shared your subjective belief of the need to defend yourself. And of course, innocence is you need to be the non-aggressor in the conflict. Now, when we get to deadly force self-defense, the element of proportionality kicks in. You have to have all those elements already, plus the threat you're defending yourself against has to be a deadly force threat, one likely to cause death or serious bodily injury, or one of these enumerated forcible felonies. So those are the conditions that need to be met for defense of yourself. But then we get to the paragraph B, which is the defense of highly defensible property statute. Why do they fold the property defense into the self-defense? I don't know. Texas just decided to do that. This could very well have been a separate statute if they wanted. That's the approach I would have taken. But nevertheless, they say the actor's belief under section A2, meaning the deadly force in self-defense, the actor's belief that the deadly force was immediately necessary is presumed to be reasonable. So you have a presumption, a legal presumption, that your belief that you were facing an imminent, unlawful, deadly force attack was a reasonable presumption. Imminent, that's imminence. Deadly force, that's proportionality, reasonableness. All those three elements are given to you. Of course, avoidance is covered under the Castle Doctrine. But you have to meet conditions to qualify for this legal presumption. And that is that those are listed here. So the most important for us is this one right here. In fact, I'll just highlight the whole thing. The actor's belief that deadly force was immediately necessary is presumed to be reasonable if the defender knew or had reason to believe that the person against whom the deadly force was used unlawfully and with force entered the actor's occupied habitation, vehicle, or place of business or employment. So here we have a broad scope of highly defensible property. Of course, it includes the habitation, but occupied habitation, but also vehicle, place of business, or employment. For our purposes with this video, of course, we're only talking about habitation. But do the residents in this video, are these conditions met for them? Were they dealing with an unlawful and forcible entry into their occupied habitation? Yes. Does that mean they have a legal presumption that it's presumed that their belief that it was necessary to use deadly force in self-defense, it's just presumed to be reasonable? Yes. Does that give them 3 of the 5 elements of self-defense? Imminence, proportionality, and reasonableness? Yes. Does the Castle Doctrine give them proportionality? Yes. Is innocence baked in the cake if you're sitting in your home and someone kicks your door in, that they're the aggressor, not you? Yes. Does that give these home occupants, these residents, every legal element they need to be privileged to use deadly defensive force against these people the moment they forcibly and unlawfully enter their home? Absolutely. Absolutely. So let's watch now just the short version. Oh, before we get to the short version, a couple of other things. There are other conditions on this legal presumption. You have to have not provoked the person. So say you were shouting, I don't know, something horrible, the N-word out the window at someone, and they kicked in your door and came in. You still have a privilege to defend yourself against that person, but you wouldn't have the benefit of this legal presumption because you provoked the confrontation. Also, they have as a condition that you were not otherwise engaged in criminal activity, except very minor stuff is forgiven for this purpose. But say the home you're in is you're cooking meth. Well, then you can still defend yourself in the home, but you wouldn't get the benefit of this legal presumption. Then we have the Castle Doctrine language. And this is what makes Texas, by the way, what I call a hard stand your ground state. So most stand your ground states, the prosecutor can't argue to the jury that you had a legal duty to retreat because you don't have a legal duty to retreat in a stand your ground state if you meet the conditions. But they can still argue that, hey, this defendant didn't have a legal duty. We're a proud stand your ground state, legal duty to retreat because we're a proud stand your ground state. But they could have retreated safely, and a reasonable person would have retreated safely, and therefore you should drop reasonableness from their self-defense claim. Reasonableness is a required element. If you don't have reasonableness, you don't have self-defense. So it's kind of a backdoor way of attacking a claim of self-defense for a failure to retreat through reasonableness instead of what would normally be expected through the element of avoidance. Because avoidance is not a required element if you're in a stand your ground state and acting in otherwise lawful self-defense. Texas takes that option off the table for the prosecution. And there's about 6 or 8 states that do this now. They're what I call hard stand your ground states. The jury is specifically instructed they are simply not permitted to consider the possibility of retreat in evaluating the reasonableness of the defensive use of force. And we see that language here. And Texas is, as we'll see, one of the minority of hard stand your ground states. So the stand your ground language reads, a person who has a right to be present at the location where deadly force is used, who has not provoked the person, and who is not engaged in criminal activity. So these are all conditions that have to be met to qualify for stand your ground under Texas law, is not required to retreat before using deadly force. For purposes of this section, in determining whether an actor reasonably believed that the use of deadly force was necessary, a finder of fact, so this would be the jury in a jury trial or a judge in a bench trial, a finder of fact may not consider whether the actor failed to retreat. Retreat is just off the table completely in otherwise lawful cases of self-defense. But today's topic is mostly this, right? The presumption that the perception of the need to use deadly force in self-defense, the belief that you were facing an imminent, unlawful, deadly force attack, and the perception that that was reasonable is legally presumed to be in place. So let's go back now and look at a very short version of this intrusion. That's the long one. Here's the short one. Whoops. What did I do? Well, it looks like I don't have the short one spooled up, but I'll just go through the long one until it gets to the point where I want it to stop. It'll be pretty obvious. So let me pull this up, and here we go.
This is the wrong fucking house. Go away. This is not your house. Get the away. This is not your fucking house. Go away. What the
Right there. Guy kicks the door open, steps over the threshold. Has he met every condition for this legal presumption of reasonableness under Texas law? And most states that have this kind of statute, it's the same conditions. Some of them have different exceptions, like you don't get the benefit of the presumption if it's a law enforcement officer in the course of their duty. Texas doesn't have that particular one. But this guy kicking the front door on these normal people, and clearly he's an unlawful, forcible intruder into the home. Has he met all the conditions for that legal presumption of reasonableness? Do these homeowners have every element they need to justify the use of deadly defensive force right now? If that guy that we hear, the resident shouting, had a firearm in his hands, had his AR at low ready, the moment that door kicks open and that guy steps over the threshold, can he light him up? Yep, absolutely. And he will be in the most defensible position you could possibly be in if he were bizarrely to be charged with some use of force crime. Now, can the homeowner screw up this scenario? Yes, it's hard to do, but people do it. They'll do things like provoke somebody to come in. They'll do things like there was a case in Minnesota where a gentleman's house had been burglarized a couple of times, and he basically set up a hide in his basement, set out objects of value to lure the next burglars in. These were community drug addicts who would do this kind of thing routinely. He lured them down into the basement, shot them as they came down the stairs. He had a Barca-lounger and a little fridge and audio equipment recording all this. He shot them as they came down the stairs. They weren't dead yet, so then he executed them in the head. And this was all recorded. And as far as this homeowner thought, this was, well, that was perfectly reasonable for him to do, but it's not, folks. If this guy had kicked in the door, stepped over the threshold, seen the gun and run away, and you chased him down the street and shot him in the back as he was running away, you think you still get the benefit of this legal presumption? No, of course not. So, but people do all those things, as crazy as it sounds. So please don't do that. And if you don't do that, you're in a really strong, legally defensible position for your use of deadly defensive force in that circumstance. All right. That is what I wanted to share with all of you today. Let me take a look and see if there's any questions that I need to address. Let's see. Yeah, I was surprised I didn't hear gunshots right there when the door came open. I can only presume the homeowners don't have guns or didn't have them accessible, which is not smart, folks. Let's see. Lots of chatter. Oh, let's see. Question: what if he was at the right house? No, you still don't have a privilege to kick someone's door in. You call the police and say, hey, we believe that the guy who ran over my daughter, that's the house. And the police settle the matter. Let's see. By the way, even if it's the right house, what do you expect is going to happen if you kick open a door? Don't you expect to get shot? I would expect to get shot. Question, law self-defense member, stogies and broomsticks, boomsticks. Question, how much amusement do you get by Twitter tards trying to shame you for giving away your free book? I don't care what people on Twitter say. To me, it's either I'm bored and I'm just poking them, or it's a viable education opportunity, learning moment for other people who will watch the exchange. But the last thing in the world I would take personally is anything on Twitter. I just don't care. Now I see someone in the chat saying cops have to announce their presence and legal intent. No, they don't. Whether or not they do, it depends on the circumstances, but it's not some universal rule. They have to do that. Okay. Let's see if there's any rumble rants. It appears not. And super chats. Let's see. Hit the refresh. And Ian Johnston, $5 super chat. Thank you very much. Says, thanks for all the insight. Well, you're very welcome. And Professor of Logic. They should teach more of that, Professor. $5 super chat says, gotta run. Just wanted to say, keep up the good work and love the content. Well, that is very, very kind of you. I really appreciate that. As we begin to wrap things up, folks, don't forget our upcoming Law Self-Defense Advanced class, the only one for this year. Sign up this month, get 10% off, learn how to be hard to convict, an unattractive target for prosecution if you're ever compelled to defend yourself, your family, your property. Learn it all in one day, taught live by me, streamed to you at your computer, the only one scheduled for 2023. Learn a lot more about this course, including the 100 questions we answer at lawofselfdefense.com/advanced, and that's also where you would register. All right, folks. With that out of the way, all that out of the way, thank you all for spending another hour with me. I always appreciate it. It's very, very humbling to get this kind of support and interest. And until next time, remember, if you carry a gun, own a gun so that you're hard to kill, so your family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Until we meet again, I imagine probably tomorrow, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.